Hey, hello, ladies and gentlemen. It's John Dove here. We've had the Civil Submissions Advocacy Club session tonight. So our members have been performing an application to set aside default judgment. So I'm just going to give some general feedback and my thoughts on the application to set aside default judgment and some of the things that I've seen tonight. So the first thing I'll start with is structure. So the key thing with the structure in relation to this application is you want to start out with a very brief introduction to tell the court effectively what it is that you're asking for. And that was set out in the first paragraph in relation to this skeleton argument. And you're telling the court what it is that you want. You might want to give the court some brief facts about the case itself, so the background of the sort of litigation. But you don't want to go into too much detail because effectively the facts aren't really particularly relevant to the default judgment application. And the risk is if you go on too long, you'll bore the judge before you get into the nuts and bolts of the application itself. So with the application to set aside default judgment, effectively you have two alternative limbs. So either you need to show that you've got a real prospect of successfully defending the claim, or there is some other good reason. And what you also need to do is you also need to address the court on the promptness of the application. Now, in relation to those points, there were cases that were cited within the skeleton argument. So what you will do is you will take the judge to the legal principles from those cases. And there's not much in terms of specific quotations from the judgments that you need to take out. So as you're going through your argument, you'll refer the judge to those judgments. You'll set out what the principle was. So, for example, we had the case of Utilise Africa, and that gives us an indication as to what the definition of real is when it comes to a real prospect of successfully defending the claim. So you tell the judge what that principle is and apply it to the facts of this case and explain why this case is more than merely arguable. Just in terms of some very basic sort of presentation points, and this is applicable to any form of advocacy, really. And the key thing is you want to make sure that you're speaking at a pace that's nice and appropriate. If you're speaking too quickly, the judge can't follow your submissions, and that makes it more difficult for you to be a convincing advocate. So the key thing to remember is keep your pace nice and slow so it's easy for the judge to follow. You don't want the voice to be too monotone as well, so you can come up and down at certain points as well, just to make it interesting so that the judge doesn't switch off at any point. And so hopefully that should keep your advocacy interesting all the way throughout. You do have a skeleton argument, and in this particular case, the 8 paragraphs within the skeleton argument were quite brief. And they're brief for a reason, because this is a skeleton argument. It sets out the basis of what your argument is, and then you're going to flesh that out with your oral submissions. So there's no need to be reading verbatim from the skeleton argument. The judge has seen it. You refer the judge to maybe a particular paragraph on where you're up to, and then explain away what the points are, expanding upon that within your oral submissions. You want to make sure that if you do have a script, try and not be reading from that. It can be quite, well, if you were in a courtroom, it would be quite obvious. And also on Zoom, it can be quite obvious when your eyes are sort of darting left to right. If you're reading from a script, once again, it's not so convincing. You might as well hand the script into the judge. So you really want to get to the point whereby it's sort of quite natural and you're not reading from that. What you want to do is treat the skeleton argument as sort of a base for the argument that you can come back to and refer to. But ultimately, you want to make sure that you're keeping that eye contact with the judge throughout, and it aids with how convincing your submissions can be. When it comes to the conclusion to this, so looking at the points themselves in relation to this case, firstly, you've got a strong argument to suggest that there's a real prospect of successfully defending the claim. You then look at the other good reason. And with this, the good reason in this particular case was that there'd been a glitch on the case management system, all the data had gone, and the email to the solicitor's client had slipped through the cracks and gone into the spam. So one thing that you really need to emphasize is that there's been sort of a mistake on the system. There's no real fault on the part of the solicitor in this case. And that's the point that you really need to be getting across and emphasizing. And then you'll buttress that when you come on to consider the promptness in this particular case, because there are, we did have cases which set out some guidance from the court as to what constitutes prompt, and you'd address the court on that. But ultimately, the point that you really need to hammer home is that there's been a mistake, and as soon as the solicitor has picked up on that mistake, he's made the application. So I think it's 2 days after he returns from holiday, he sees that the application has been put in for default judgment. As soon as he sees that, he sets in his application to set that aside. So he's acted promptly. And one way you can address the judge on that is by saying there's nothing else he could have done. Or as Alan pointed out before, what you can also say is maybe pose that as a question: what more could he have done? And then that feeds nicely into your conclusion. So you'll effectively summarize the points for the court and then ask the court to set aside the default judgment. You need to be very careful in the way that you phrase the final sentence in your conclusion. So there was one, I think it may have been a slip of the tongue, but one individual said, "I'm going to compel the court to set aside default judgment." We never tell the court what they're going to do. You're challenging the judge there. So you would say to the court, based upon my submissions, I would ask that the default judgment be set aside unless I can assist any further. So hopefully those were a few points to help you. Alan, did you have anything to add at all?
Well, as always, you cover everything. A little phrase that's very useful for your career is, "I adopt the submissions of my learned friend." That gets you out of a lot of speeches. But yeah, just this overall thing in advocacy generally, and I keep repeating this point, but as advocates, we see cases as battles to be won. For judges, cases are problems to be solved, whether that's a trial or a little application like this. So help the judge solve the problem. Make it very, very, very simple for them. Introductions to tell the judge who you are, what you want, why you should get it. May it please the court, I am Joe Bloggs. I appear on behalf of the defendant. We seek to set aside judgment default. The grounds for setting aside the judgment default are: we have a fantastic defence, which unfortunately we didn't get to present because of a technical glitch. Something like that. Keep it nice and summarise it. Have a structure, tell the judge what the structure is. I'm going to address you on the following 3 points. And you'll do this if you do jury advocacy. As soon as you start saying, I'm going to do X points, you'll see people pick a pen up. It helps them focus, it grabs their attention. And the other thing is, which I'm going to demonstrate by getting it, by way of example, is have a decent way of finishing. You'll work on everything, you'll do your fantastic opening, but sometimes cases, you'll sort of fizzle out your argument and you'll start repeating points. It's quite good to have, because even if you're working from bullet points, maybe have your introduction sort of set out in some detail, but also have your conclusion set out in some detail. So in summary, the grounds for setting aside this are that we have, as near as you can get to a slam dunk defence. The fault was merely a technical glitch and there was no actual, intentional fault there. And as soon as the fault came to light, it was remedied immediately within 1 day. So unless I can assist you further, those are my submissions, something like that. So yeah, and the other thing, just general advocacy points: modulate your voice, speak very slowly. Remember, it's not a lecture, it's a dialogue. Engage the judge, modulate. Whether if you're somebody who's quite animated, you don't need to be waving around that too much, but you can use body language and watch what the judge is doing. And remember, judicial intervention is actually a good sign. A lot of people hate it, but actually that's the judge giving you very valuable feedback as to what they actually think is important. And if a judge is saying, well, address me on X point, that means that's the point they care about. You might be pushing at an open door on all the other points. But so even if you've been up all night crafting your wonderful argument, if a judge says, I want to hear about X, you've got a choice there. You can either say, I'll just move on to X and address it. You can say, that's a brilliant point, which I'm just about to come on to, and just finish off where you were. And sometimes you do need to be able to sort of, go off on a little subroutine and come back in if you've actually got some brilliant points that you want to end on. So it's striking a balance between making the points you want to make, but not just completely ignoring what the judge, has expressed their interest actually is. So that's how things are, engage with your audience, whether it's a judge or a jury or a lay bench or whatever. Watch what they're doing, be human. me and John have this slight difference, don't you? Because you know, when people said it's not a conversation, and I sort of say, actually, I think sometimes it is a conversation, and especially as you get on your feet and you get to know the judges, you will actually engage a lot more in a more free-form sort of, you know, way of doing it. But a good test for how you should present a case is, if the night before the hearing, one of your friends asks, you know, what you're doing tomorrow? Oh, I'm doing this application. What's that about then? The way you explain it to your friend in the pub is probably the best way you can possibly do. So explain it to the judge that way. One judge actually said the best way to address me is, imagine you're down the pub the night before and you're trying to explain what you're doing tomorrow to a friend who's a bit interested, but also trying to watch the football. So,
Really good advice there,
that's what
actually.
you're hearing for.
Yeah, but no, I completely agree with you on that point, Alan. It should be quite conversational, to be honest, because that's sort of I think that's the easiest way to get your point across. You know, if you're treating it almost like a conversation. Obviously, you're not going to use any colloquialisms or anything like that. But the point being, you know, if you can talk to the judge in really simple language, break it down in a way that a 5-year-old could understand, then that's a really persuasive piece of advocacy. The easier your advocacy is to understand, and the more natural it is to follow the point, then I think you've got a better chance of actually being successful on the application itself. So so don't feel the need to be overly lawyerly, if I put it that way. No need to use long words if you don't normally use them. Use complicated language that's going to confuse everyone in the courtroom. Keep it simple, and that should really boost your chances. So I hope that advice has been helpful.